Good evening, everyone. You are most welcome to this final round, as earlier introduced. My name is Amperio Victor Rugaba. I'll be the clerk for this round. This is the matter of This is the matter of Grace Navunya and Samuel Katumba versus Nakaseke Bright Future School. I shall indeed hand over to the judges. Please indicate the time that you shall be using before you speak, as you've been doing, so that we can keep the time. Thank you very much.
Right. Thank you. Again, welcome to the final round of this moot. As always, the most entertaining outcome is the most probable. Yeah. So have fun, enjoy yourselves, and give us a show, and give yourselves a show. All right? So who are the applicants? Applying, responding? All right. Could we have a list of your names? Yes. Just list down in the order of appearance with the team code so that we can reassure which teams are before us. Okay. And with that said, we are ready when you're ready. Please, the applicant. Yes, please. Oh, yes. Those of you who are rich enough to own mobile phones, could you kindly put them in silent or flight mode? Please observe decorum. It's not just for the people who are at the bar, but also people in the gallery. Please observe decorum. So we'll not be expecting you to walk around, move around, or otherwise disrupt the process. Okay? Once you sit, make sure that you're settled and you're not going to move once you're done with that. We're good? Right. With that said, let us have the applicant, please.
May it please this honorable court, I am Namirembe Juliana, the senior counsel for the applicants. Along with me, my lords, is my co-counsel Muzachi Alana. We shall divide this honorable court's time as follows. I will use 8 minutes to handle issue 1. My co-counsel will use 10 minutes to handle issue 2, reserving 2 minutes for rebuttal. My lords, I maintain that this honorable court has unlimited and original jurisdiction as provided in Article 50 of the 1995 Constitution. In addition to that, Section 3, which is read with Section 2 of the Human Rights Enforcement Act, describes this High Court as a competent court. However, my lord, my clients are claiming compensation of 70 million, which exceeds the pecuniary jurisdiction of the Magistrates Court.
However, I'm not sure what the probative value of that is. You said, however, your clients
are claiming a compensation of 70 million, which exceeds the pecuniary jurisdiction of the Magistrates Court, hence submitting our case in this court, my lord.
But, counsel, is this a rights enforcement case, or you're more interested in compensation?
It is a right enforcement case.
Yes, so why exactly are you telling us about the value of the case?
It's because this case involves violation of human rights, such as a right to education, the right to respect and dignity of persons with disabilities, as stated in Article 35, my lord, Clause 1 of the 1995 Constitution, and yes, my lord.
Counsel, I think what he's driving at is the end goal for you to get the money, or is it for the enforcement of those rights? And why are we having the 70 million figure, for example, when you have rights violations?
No, my lords, it is
Counsel, to further help you with that, if the value was less than 50 million, would this court still have jurisdiction?
No, my lord, because Section 2 of the Human Rights Enforcement Act states that the magistrate's court does not have jurisdiction over a court case that claims compensation of over 50 million.
Yeah, but Counsel, you're in the High Court.
Yes, my lord.
You just said, I think you're confusing the two. Yeah, the reason why I brought the first question is that the pecuniary jurisdiction in and of itself is not in question, so you should not have gone there at all. Yeah, the High Court can hear, as you said, original jurisdiction in all matters. So it doesn't matter how much money you're asking for. It doesn't matter. That's not in contention at all.
Okay, my lord, I beg to withdraw my statement of the compensation.
No, it was a correct statement. The statement is correct, but it was just in the wrong place. But it's okay. Maybe if you could address the other questions.
Counsel, to further help you, the High Court in human rights enforcement matters has jurisdiction regardless of the value of the subject matter. So if it's a human rights enforcement matter, then the High Court has jurisdiction regardless of the subject matter. You understand?
Yes.
That's what we're trying to drive you at, but at least now you understand it, so you can proceed with your arguments.
Yes, my lord. Without further ado, I will handle issue 1, which is whether the exclusion of my clients, Grace and Samuel, into alternative classes and the financial burden imposed on their families violates Article 21, 30, and 35 of the 1995 Constitution. My lord, my argument will center around 3 arguments, my lord. First of all, my lords, education is both a human right in itself and an indispensable means of realizing other rights as described in General Comment number 13 of the ICESA. With this, my lord, the applicants aver that their right to education, which is provided in Article 30, was violated by the respondents. Our Constitution provides that my clients have a right to education, and with this, we believe that the respondents did not fulfill this particular right in this regard. At Article 24, my lord, under the United Nations Convention on Rights of Persons with Disability, it provides for inclusive education. However, my lord, it is evidenced in paragraph 9 of the facts that my clients were told that they were going to be taken to alternative learning classrooms and hence moved to alternative learning classrooms. Inclusive education, my lord, is not about separate rooms. It is not about being given outdated materials as it was stated there. And my lord, I would want to make this court alive to the fact that outdated does not have a specific meaning in our books of law. However, the 4th edition of the Black's Law Dictionary explains outdated as something that is no longer in use. With such means, my clients cannot have an inclusive education. They are being told to use outdated materials. In addition to that, they have been taken to an alternative learning classroom, my lord, where they are referred to as a left-behind class, evidenced in paragraph 9 of the facts, my lord. This violates their right to education. This takes me to my second argument, my lord.
Counsel, before you proceed, inclusive education is your point, right?
Yes.
However, does inclusive education also take into concern the different capabilities of different learners requiring special treatment for each group?
Yes, my lord, it does take into account that different learners need different things. However, my lord, it is evidence that my clients were given outdated learning materials. Outdated means that there's a disparity in the standard that they're receiving, contrary to that which other students are receiving. Does that mean that Article 30 only complies with the other students that receive this quality standard, while my clients are not able to receive the quality standard that they deserve? I do not think so, my lord.
Counsel, are you conveniently ignoring the fact that these books were complemented by AI material?
I beg your pardon, my lord.
Are you conveniently ignoring the fact that what you refer to as outdated textbooks, was in fact complemented by AI material that perhaps one could argue meant that these students were in fact getting better and more quality education?
My lord, it is seen in the facts that my clients were taken to an alternative learning classroom with AI generated, yes, and the outdated learning materials. However, the other students were able to have this AI itself use it presently, in addition to the fact that there were teachers in those classrooms, but in no way were there teachers with the other students, my lord, because it is not shown in any of the facts, my lord.
Counsel,
Yes,
can one argue that the outdated material are in line with the progress of the students? Is there any way you can tie the material to the progress that some students, due to slow progress, require, let's say, edition 2 as opposed to edition 8 of a given textbook?
My Lord, I really do not believe that if the others need something more, they're supposed to be given outdated. They're supposed to, if they require more, then they're supposed to be given something of standard to ensure that they are able to meet their right to education, my Lord.
So the learning progress of someone has no bearing on the type of book that they should get? A slow learner doesn't require a low edition and a
They do
fast
not
learner.
require something that is substandard because it is their right to quality education.
Proceed.
Thank you so much, my Lord. This takes me to my second argument. The applicants aver that their right to respect and dignity was violated in accordance to Article 35, Clause 1 of the 1995 Constitution. My Lord, Sub-Article 2 mandates Parliament to enact laws for protection of persons with disabilities. Hence, the Persons with Disabilities Act Cap 115, which provides inclusive education. My Lord, Grace and Samuel dreamed of being part of their peers as they are studying. But when they were taken to what is termed as a left-behind classroom, they were ripped of their dignity and their respect. Yet it is provided for them as a right in Article 35, Clause 1 of our Constitution, my Lord.
Wouldn't the respondent argue that that was in fact positive discrimination to give the students special attention?
Whereas the respondents may argue that it's positive discrimination is supposed to be taking forward steps. Yet they were not taking forward steps because they were giving my client substandard quality, my Lord.
Counsel, what would you rather that should have been done in this instance?
My Lord, I would rather that my clients would have been assisted with sign language helpers in the other smart class AI classes alongside these other children, because that would make them feel included in the education. My Lord, education is not just about learning material, but it's also about the experience of learning from your peers. When they're excluded, they're unable to learn from other people as they ought to be in regulations with Article 30, my Lord.
Please proceed.
This takes me to my third argument, my Lord. In the words of the renowned humanitarian and diplomat Eleanor Roosevelt, where after all universal human rights begin, in small places like homes and schools, the exclusion of my clients was a violation of Article 21 of equal protection in all spheres of life.
What is the value of Eleanor Roosevelt's words that you've just referred to?
My Lords, it is just an opening statement to open the House's mind on the fact that human rights begin in the smallest places, such as schools and those alternative learning classrooms. That is also where our universal human rights begin. The exclusion of my clients was a violation of Article 21 for protection. My clients have not been protected as the alternative learning classrooms have been a field or a route of discrimination and further bullying, when my clients assert that they feel like second-class citizens. With my time first spent, my Lords, it is our prayer that the respondents be held that their actions were a violation of Article 21, Article 30, and Article 35 of the 1995 Constitution, with a compensation of 70 million to the applicants and a public apology for the psychological torture that my clients suffered in those alternative learning classrooms. Much obliged, Your Honor. I submit.
Ladies and gentlemen of this honorable court, my lords and our learned friends for respondent, as earlier introduced by my co-counsel, I am Muzachi Alana Chirabo, and I'll be addressing issue 2. My lords, I am here to demonstrate that the collection of biometric and personal data without consent violated the right to privacy. Under this issue, I'll be fronting 3 arguments. Argument 1 is that the collection of biometric and personal data without consent violated the Data Protection and Privacy Act. Argument 2 is that the same collection of biometric and personal data violated the ICCPR. Argument 3 is that the respondents' actions did not pass the test of limitation under Article 43 of the Ugandan Constitution. My Lord, it is the applicant's submission that the respondents' actions of collecting data without consent of the parents violated Section 8, subsection A of the Data Protection and Privacy Act, which states that no one will collect prior consent.
Counsel, when you mentioned that there is no consent that was given, yet in paragraph 2, the Ministry of Education rolls out this program in this specific school. Secondly, by virtue of the fact that parents actually brought their children to these schools, it seems to me that there is prior consent. given the fact that they are not required to give any other written consent in regards to the curriculum, the meals provided by this school. I'm wondering what's so special about this consent that was required when it's not given on other services that are provided by the school.
My Lord, I'd like to first address your first question that's saying merely bringing a child to school does not amount as consent to take their data anyhow. My Lord, especially since we're dealing with AI, which is a high data security risk technology. And secondly, addressing the issues of the national curriculum and the meals provided by the meals provided by schools. These are duties done by the school. The parent has taken their child so that the school can fulfill these duties of feeding them, of providing for them a right curriculum, and the curriculum falls under the government of Uganda. Yes, please, ma'am.
Question. Do parents always have to have a say in the means or the mode of teaching that is offered to their kids that they take to school, or can the school make the determination?
Council, further in line with that, is there a distinction between consent to curriculum and consent to the data that is taken from students?
I think the determination of school meals should be held by the school because the school knows its budget and it will plan according to that budget, as well as the curriculum. My Lord, it is not of the school, but it is of the state. So if the government imposes a curriculum on the school, then the school is under duty to perform that curriculum. And addressing your issue, my honor, would you please repeat your question?
My question is in line with, is there a distinction between obtaining consent for curriculum and obtaining consent for data obtained from students?
Yes, my Lord. This is because data can be used anyhow. We have seen instances of people forging nudes, of people forging pornographic videos from this very data. Yes, the national curriculum is a decision made by the government, but whatever happens with this data may damage the mental health of a child, which no one would want.
We agree with you. However, still to the question, you have the ministry saying we are rolling out this system of learning, and we are saying, to your own admission, if the curriculum is from the government, then the school should in fact implement. So what happens in case where the implementation of said curriculum requires the collection of data for the system to work? Do parents need to give specific consent in such cases, or can the school just proceed to implement by collecting data and implementing said curriculum?
My Lord, could you please rephrase that question for me?
The question is simple. Do parents need to give extra consent in cases where the school is just trying to administer a curriculum that has been imposed onto them by the state? The point being, the collection of data in this case was in line with the requirement for the smart AI classes, right? So did parents need to give specific consent for their kids' data to be taken before the school rolls out this AI technology?
Yes, my Lord, the parents needed to give consent.
Yes, why? And that's what we want to know.
Because the education of a child befalls both on the state and on the parent, as of Article 34, Clause 2 of the Ugandan 1995 Constitution, meaning that the parent should be held accountable for the education that their child is receiving. And if the state is implementing a curriculum, then parents should be aware of how this curriculum would work.
Council?
Yes, please.
Would I be right to say that you're trying to put the right to privacy at the same footing with the right to education, and I find that problematic?
My Lord, I'm not putting them at the same footing. I'm saying that the right to education has extended its limitation on the right to privacy.
In what way?
My Lord, in the Supreme Court case of Charles Onyango Obo versus the Attorney General, it was stated for a limitation to be held that it must be lawful, that it must achieve a legitimate aim, that it must be necessary, and that it must be allowed in any in any democratic society. My Lord, whereas I understand that the Data Protection and Privacy Act is a law and the objective is education, Requirement 3 and Requirement 4 were not met. On the necessity, the Supreme Court in Charles Onyango Obo versus Attorney General stated that for any limitation to be necessary, it must be proportionate. The respondents collected a lot of data which is more than necessary for education. For example, they collected fingerprints and voice recordings which were not accounted for in any of the facts. They only accounted for facial scans which were said to monitor attention in class and to monitor attendance.
The respondent would argue that the fingerprints and voice recordings are being collected for the mode of examinations that these AI tablets are going to use for the integrity of the examination.
My Lord, I'd use the analogy used in the Supreme Court case of Charles Onyango Obo versus the Attorney General, that the state should not use a hammer to hit a mosquito. They have overly done the collection of data without accounting for any of the data that they have collected.
So, on proportionality, what is your view that perhaps the state could have sought consent, that being the less or least intrusive way or measure that could have been adopted, as opposed to just doing whatever they did without seeking prior consent of the parents?
Counsel, further to that, the respondent could argue that the logistics involved in getting that consent would be tedious and lengthy, hence justifying the need to roll out the program, since it's a pilot anyway, and won't be that harmful. So, for example, imagine a parent reporting to Gayaza with their daughter or any other school in the country, and at the entrance they are required to sign a consent form, as opposed to maybe the school saying, look here, let's see if this works. And if it works, then we can go to the parents and get the consent. Would one argue like that?
Could you please help repeat your question for me, my Honor?
What I'm saying is that the respondent could argue that the logistics involved in getting the consent, okay, would mean that the project wouldn't go ahead. So they said that since it's a pilot, let's test and see how it works. If we define that it works, then we shall get the consent for the actual system rollout. You understand?
Yes. My Lord, I believe that any parent would want to see their child succeed in school, to receive education that is more than substandard. So I don't think that asking for consent is tiresome or tedious, as you said. I think that it is necessary because a parent needs to know what's happening in their child's life. A parent needs to know if their data is being collected, because you never know what could happen with this data, as I earlier stated. Your Honor, could you please help me repeat your question as well?
My question was simple, that the proportionality test that you make reference to requires that the measure of interference that you adopt should be the least intrusive of the available alternatives. And my question is, do you think that asking parents to consent was the least intrusive measure that perhaps the state should have adopted?
No, I do not, Your Honor. May I proceed to my argument?
Please.
Under Requirement 4, I'd like to inform my lords that no democratic society would allow excessive data collection of minors, especially if it's being stored on servers outside of Uganda.
I'm sorry. You keep speaking to excessive collection of data, but what test are you using to determine that?
My Lord, I am going to refer you to paragraph 5 of the facts that say that the facial scans were used to monitor attendance and attention in class. My Lord, it is the only form of data that is accounted for in all of the others that have been collected.
Thank you. Does the data collector or even processor need to always account for the data that is being collected? And where does that obligation come from?
Yes, my Lord, I think that the data collector should always account for the data that is being collected, because at the end of the day, it's not their data being collected. They have no right over the data that is being collected.
Where does the obligation come from?
My Lord, I have not addressed myself to that question.
Counsel, do you happen to understand the principles of data collection? And do you know where those are found in the Data Protection and Privacy Act?
My Lord, I know that they are found under Section 7, but I do not know the principles of head. So if you may allow me to look through my resource back.
Council, what we're trying to ascertain here is that a data processor has obligations, okay? And one would argue that accountability would be that obligation. So, in your view, how accountable should a data protector be, given that you say that the data doesn't belong to them? So, in your view, what kind of accountability should, let's say, a company like MTN give you for what is obtained from you via your national ID?
I think that MTN should give me in detail the data that they're collecting, so that at the end of the day, if I was to ever complain, I already knew that MTN already had my data. So it would lessen the work of MTN if it just gave me the data it was collecting, and we could end hearings like this on data collection and data privacy. Imagine if the Nakaseke Bright Future Secondary School had asked for consent, we would not have come to this hearing to be addressing this issue.
Council, are you saying that giving consent waives all the rights of complaining from the effects of collecting that information?
No, my Lord, but I'm saying that it reduces the amount of complaints that are going to be made.
Yes, my question was about your complaint that this data is being stored outside Uganda. If you look at that part of the fact, they say this is just a rumor.
My Lord,
I find it problematic that you want us to base our decision on rumors.
My Lord, the fact that such an outrageous rumor has not been responded to is an adverse inference, which means that it is a dangerous hint to something bigger. Why haven't the respondents addressed this issue if it is not true?
Proceed.
My Lord, I'll now proceed to the second head of argument. My Lords, the applicants aver that the respondents' actions of storing data outside Uganda, contrary to Section 19.
Your time is up, but just
make my prayer.
Summarize the argument and then you make your prayer.
Okay. Contrary to Section 19 of the Data Protection and Privacy Act, that section requires that before data is stored on outside servers, that it must have the data subject's consent, and adequate measures must be put in place to store this data. Under paragraph 6A of the facts, it is seen that the respondents did not seek consent, neither is there any evidence to adequate measures of protection. With this, my Lord, I hereby pray that this court grants us a compensation, the applicants a compensation of 70 million, and that the collection of biometric and personal data was deemed to have violated Article 27 of the 1995 Ugandan Constitution. Much obliged, Your Honours.
Thank you very much. Respondent?
Very much obliged. May it please the court. My name is Yiga Eric, and I'm appearing alongside my co-counsel, Roman Asmero. My obligation today, within 10 minutes of this court's honorable time, is to address issue A of this case, and within 10 minutes still of this court's honorable time, my co-counsel will be handling issue B of this case as well as saying our prayers. Before I present, my lords, I seek leave of court to make my opening statement.
Proceed.
Thank you very much. What stands before this court is not injustice. It's a very difficult balance between rights and responsibility. The case today is not about neglect. It's about the respondent, Nakaseke Bright Future Secondary School, trying its best within its financial and technical limits to see that every child gets the best that they're entitled to. My lords, I'm going to be addressing whether the measures taken for children with disabilities, including separation into alternative classes and the specialized devices presented as an option, represent reasonable accommodation and progressive realization within the school's financial and technical limits. we contend that they indeed do. And to that, we have two heads of argument. The first about reasonable accommodation, but second also about progressive realization. But first, I want to respond to some of the issues and contentions that were raised by the applicants in today's case. First, they come and tell us that the exclusion is discrimination, separation is discrimination. And to that, they say this is because these children are having outdated material. The AI systems don't match the AI data, and the extra financial burden imposed onto these parents. Chair, my lords, separation is not discrimination. Let's get into the facts. According to Article 21 of the Constitution of Uganda, Clause 3.
Council, how do you reconcile that argument with the leading case in the world on the separate but equal doctrine, which is Brown Board of Education versus Topeka, where the Supreme Court of the US said that providing separate schools for black students from white students was separate but unequal, hence being unconstitutional. So how do you justify a separate classroom in a school where a court somewhere in the world is saying a separate school is unconstitutional?
I'm very much obliged, my lord. That brings me to the next submission, which is, in the case of separating blacks from whites, it's discrimination. Why do I say so? Because this differential treatment is based on grounds of race. That is to say, if you're black, even though you're better than the whites,
isn't discrimination, doesn't discrimination recognize disability as a ground?
Yes, my lord, and it recognizes that in Section 4, subsection 1J of the Child Act. However, as I submitted earlier, discrimination is supposed to be on grounds of that particular aspect. That is to say, in the case of the blacks versus the whites, in the case stated by our dear honorable judge, this differential treatment was attributed specifically to race. That is to say, you're black, I'm white. We don't deserve to be in the same place. What happens within the facts? These children are not separated because they are disabled. They are separated. The grounds for this separation is to help them, is to provide them with extra help.
Counsel, why were they separated from their colleagues?
They were separated from their colleagues in order to help them learn better.
Why did they want to help them?
They wanted to help them because they were disabled and because they were unable to use the AI tablets.
So it was because of the disability that they had to separate them?
Yes, my lord.
Okay, then we can proceed.
Counsel, if we were to agree with your argument that the basis for separation was not discrimination, is discrimination only defined at the point the separation is done or at the effects that the separation actually causes, like them being called second-class students or those who are left behind? Isn't it discrimination even at that point?
My lords, it is discrimination at the point that they are called the left behind class. However, when you look at Article 21, sub 6, clause 3 of the Constitution, it's differential treatment. That means that if the school carried out this separation on grounds of helping them, that does not account as discrimination from the school itself. To add more to the issue of discrimination, I will go into my first head of argument, which is reasonable accommodation.
Yeah, Council, before, okay, yes, as you go into your first argument, especially on reasonable accommodation, I want you to, in addressing that, to show us how giving them outdated materials is reasonable, and then the alternative of requiring them to pay more money if they are to access this service. Just show us how reasonable that is.
Very much obliged, my lord. If I may, I would like to start by stating the legal instrument I'm going to be referring to and further diving into the logic. Reasonable accommodation, according to Article 2 of the Convention on Rights of Persons with Disabilities, read together with General Comment Number 6 on Equality and Non-Discrimination by the Committee on Rights of Persons with Disabilities, provides a 4-part test of what reasonable accommodation is supposed to look like. The first is that it should be interactive and flexible. Second is that it should be individualized. Third is that it should be timely. And fourth is that it should be proportionate. In this case, proportionality means that in as much as it needs to balance the needs of the person it's targeted toward, it must fall within the provider's capacity. We contend that Nakaseke Bright Future is a poor school that have limited resources. That is attributed in the low pass rate. The low pass rate is an indication of underlying problems such as shortage of teachers, shortage of learning materials, and all that, and all that. That means that they were doing whatever they could within their reasonable capacity as a poor school to accommodate these students by separating them from these classes where they couldn't benefit and putting them where they could help them better. Secondly, on that submission, why we think that this kind of separation is good in and of itself. These classes were made for these students to have translators such that they can help them understand what these AI tablets are actually doing, putting them at the same level as the other students that were learning in class.
Council, does the court consider, in terms of obligations, what a party meant or what a party did? So, in that context, I can give an example of my mother. She would beat me for what I did, but not what I didn't intend to do. So, should this court look at what you intended to do, or should it look at what you did?
My lords, according to the facts, it is stated that these students were put into separate classes with special help. That special help means that the school targeted these students particularly, putting them in classes where it was able to better help them in means such as providing for them teachers to interpret this AI data. Does that answer your question, Honorable Judge?
What I'm saying is that as a courtroom or as a judge, I would prefer things that are tangible, things that I can feel or see. It would be hard for me to read what you intend to do as opposed to what you've done. So from what you've done, what shows that you have good intentions? From what you've done, from the facts, what have you done that can at least tell us, look here, we are resource constrained, but in future we shall do better. Because for you to say, I'll do better, you must at least do something now.
My lords, according to paragraph 1 in particular and paragraph 4, there is a 46% increase in pass rates. That is something positive that has been achieved by this. In addition, according to paragraph 8, the head teacher assures the parents in a Parents-Teachers Association meeting that the ministry is exploring inclusive upgrades in the next phase when the special devices are going to be launched and they would...
Yes, so thank you for that, Council. What is stated under paragraph 10, the very last sentence?
The Board of Governors, the very last sentence.
Yeah, from in addition.
They exclude these children's results from the school statistics to avoid distorting improved national rankings. However, this exclusion is not still based on the fact that they are disabled. This is a pilot study. That means that we are going to give you an AI tablet and we want to assess its benefit, its effect on you as a scholar.
No, my point is that the improved performance you're telling us about appears to be a smokescreen because you've excluded these students from the statistics.
If I may, my lord, the exclusion from the school statistics represent the people that were using AI tablets. That is to say, the class that was studying along the other learners that were using AI tablets and had no problem. They were the test subjects of this pilot study. However, the disabled students that were separated into alternative classes, not because they wanted to discriminate against them for being disabled, but because they wanted to help them better in a system that was not favoring them. These students were not test subjects for this pilot study because they weren't using specialized AI tablets. They were simply being taught with teachers using AI materials and some outdated books.
Council, what my learned brother is trying to point at is that if you're excluding some people from your statistics,
yes,
why should we trust the other statistics? Because the others could also be something that you're giving us to make us happy. So what kind of assurance can we have that the improved performance is genuine to justify your separation of those that are not improving to improve them? Because the separation could be a reason of something else, because we are not sure even the improvement is genuine. Because if you're removing those that are not doing well, what makes us believe that you're not including others that are not doing well, but you're making it look like they're doing well?
My lords, if I may, I would like to use an example to explain the matter. The example I'm going to use is about a company trying to introduce a new headset technology on the market. What they do is that they get a group of 100 people and they want to test their technology on them. So they give each and everyone a pair of headsets and they ask them for the quality of the music. However, some of these 100 people that are listening to this music are unable to hear. Therefore, they are excluded from therefore their results are excluded from the statistics when they're publishing their report. Does that answer your question? Proceed. My dear Honorable? Yeah. I would like to proceed to explain Article 2 of the Conventions on Rights of Persons with Disabilities, which is that reasonable accommodation shall not impose disproportionately on the provider. That is to say, as already explained, it's not right for reasonable accommodation. My lords, I please request 1 minute to conclude my case. It's not proportionate to this school because it's poor and it's imposing disproportionately on them. My lords, we pray that this honorable court makes a finding that the respondent realized the rights to the best of their abilities, given their limited resources and capacity. The exclusion of students from the normal classes wasn't based on the reason of discrimination. These students were excluded as a means to help them better within the society that they existed. And furthermore, we've achieved a 46% increase within 2 years of introduction of smart class AI system. It's a pilot study. That means there is room to make mistakes. However, the essence of this is that we can improve these mistakes when the real project is actually being launched. If I may be of no further indulgence, I seek leave of court to yield the floor to my co-counsel.
Please. Thank you.
You're very welcome.
Much obliged, my lords. My name is Herman Asmeram, second counsel for the respondent, and I'll be using 10 minutes to submit our case and make our final prayers. My lord, I'll be handling issue B. My lords, I seek leave of court to make my opening statement.
Yes. You don't need to, just proceed to.
Much obliged, my lord. My lord, I'll be handling issue B that states whether the data collection is lawful, necessary, and proportionate and serves legitimate aims such as promoting education, safety, and preventing exam malpractice. My lord, as counsel for the respondent, we indeed contend that this is lawful, necessary, and proportionate and serves legitimate aim. Under two heads of argument. A, the right to privacy isn't absolute, and B, this passes the permissible limitation test. My Lord, I proceed to our first head of argument. The right to privacy isn't absolute. My Lord, under Article 27 of the Constitution of Uganda, which protects the right of privacy just like our applicant submitted, however, this is as well read alongside and interpreted by Article 43, Clause 2C, that states any limitation shall not be beyond what is acceptable and demonstrably justified in a free and democratic society. My Lord, this is further evidenced in law case of Charles Onyango Obo and Anor versus Attorney General, Constitution Appeal 2 of 2002. This is very important, or evidenced in our facts of paragraph 5 that states that already Nakaseke is within the Uganda premises, which Uganda concedes to be a democratic society because of the constitution. But then also we submit that this has been done for the good of the education sector to monitor the attendance as well. My Lords, I proceed to my second head of argument, that is...
No, before you proceed, just because it's for the good, as you say, it's going to promote education, does that mean that you bypass consent?
Much obliged, my Lord. My Lord, due to the social contract that citizens who are part or under government has the absolute powers over their rights, we submit that privacy isn't absolute, because at the end of it all, this is for their better goodness of their children's interests.
Counsel,
my Lord?
Counsel, are you saying that in the sense of a social contract, what we understand as a social contract is that the citizens elect the government to serve them?
Yes,
so
my Lord.
If the citizens, including the parents, give a mandate to the government, how best can the government include the parents in decision-making process?
Much obliged, my Lord. Yes, parents elect the government. This simply means that it's democratic, as I stated above, but then also parents have a lot of trust within government. But secondly, they didn't give the consent simply, just like our applicant submitted, because the process through which the consent is going to go will not provide immediate effect. My Lord, we see this that in paragraph 1 from 21%. Yes, my Lord.
What was the rush on your end?
Well, my Lord, this was a pilot survey and it needed to be done in order to implement.
Did it need to be done immediately to the extent that you do away with consent?
My Lord, the effect of this was that it improved from 21% to 67% in a short time, but also this pilot study...
And should we then take the improvement of results above constitutionally guaranteed rights?
Much obliged. As long as the violation passes the permissible limitation test, then we submit that because it's for the betterment of the children, then we deserve to take it ahead.
Okay. Thank you. I think it's good that you mentioned the limitations. However, before you get to the limitation provision in the Constitution, right, you need to first deal with the general rules that are set out in the under the different provisions that provide for the different rights in the Bill of Rights. So, did you even attempt to get consent first before you move to the limitation? You can't just jump to the limitation. The limitation is, in fact, an exception to the general rule. So you can't just jump to the exception unless you have very specific, concrete reasons for doing so. So that's what we want to hear.
Counsel, in simple terms, okay, when you have an agency, okay, let's say I'm trying to get married tomorrow, and I need permission from my parents to get married. At the moment, my parents are in London, so I can't get permission from them. You understand? So can I go to a mosque tomorrow and I tell the sheikh, you know what? I know you need my parents' consent, but they're not in the country. Let me reverse it. Supposing my parents are in the country, they're at home chilling, and they don't want me to marry the person I want to marry. And I know that. So I don't bother going to them because I know they will say no. So I just go to the mosque and tell them, you know what, my parents died. Can you marry me? So in that scenario, okay, should the government say, look here, this is a pilot study, let's see how it happens, then get the consent, or should the government say, let's try to get the parents, and those that accept, we do this pilot study on their children, those that say no, we let them go. Do you think that is better?
Much obliged, my lord. My lord, addressing the first question of why jump, we believe that at the end of it all, it's for the betterment of the education sector. But then, to respond closely to your question with my lord's question of why jump, we believe that mere fact or by default that a parent takes the child to the school simply means two things. A, they believe in the authorities of the school and as well as the government that is passing that rule. Meaning, consent has a longer path that it has to take, yet this is something that needs to be taken urgently. But then two, we believe that due to the stereotypes that exist within society, parents, not largely, but to minority, could refuse this, yet this is in better interest of the people. My lord?
Wouldn't it be well within their rights to actually decline to give you consent?
Well, I believe that some of them, out of ignorance, may refuse. Therefore, the government is in better position to do this for the best interest. My lord?
Council, you talked about the test for limitation.
Yes, my lord.
Address us on that test and demonstrate to us how you passed that test.
Thank you, my lord. My lord, just to highlight, the applicant came here and said that we did not pass the limitation test. However, they did not efficiently show us how that was done, so we cannot base on their case. Back to my argument, that is where I was heading to argument 2.
No, address us, demonstrate to us that your limitation was justified.
Yes, my lord, that's where I'm proceeding. So, the permissible limitation test is a 3-part test under lawful, legitimate, necessity, and proportionality. Under lawful, this is seen under the Syracuse principles that the right to privacy may be limited under situations in Section 7, subsection 2 of the Data Protection and Privacy Act, which is by a public good by a public body for a public good. Therefore, this is further evidence in paragraph 2, Part A, which shows that the Ministry of Education, which is in charge of education and is a body, did this.
Address us on what is most contentious. I believe it is the necessity and the proportionality component.
Yes, my lord. To the point of necessity, this simply means that it's needed to achieve a legitimate aim, which we show you is education. This is further got from Section 7, subsection 2 of the Data Protection and Privacy Act, that no data is to be collected unless authorized by law. This has been authorized by law. But moving forward, under the general comment on general comment number 25 on children's rights in relation to digital environment by the Committee on the Rights of the Child, paragraph 67 states children's personal data on process to offer educational, health, and other benefits to them. This simply means it was in the best interest, and according to paragraph 67, it shows the necessity. My lord,
Counsel,
it's...
Yeah, given, if we are to believe that, but the applicant made an argument that I would like you to respond to. They say that
yes,
you're collecting too much data.
Well, my lord, we believe that is not too much data. To break it down, that goes to the proportionality part of it. The facial recognition is used for monitoring the attendance and the attention span. The biometrics and the fingerprints are used to monitor the exam malpractice.
Let's go one by one. Don't you find monitoring someone's attention span very intrusive, especially for a child?
Well, my lord, my first head of argument, I say the right to privacy isn't absolute. So, infringing on their right for a better cause.
Yes, we have moved from that, but now we are interrogating the proportionality of that and how intrusive it is.
Yes, my lord.
So here you're monitoring a learner's concentration span? Could then that be achieved in some other means?
No, my lord.
So especially with paragraph 6b indicating that with this information being collected, predictions by these machines are being made and predicting that these students will most likely not to succeed beyond a certain education level, which can be very discouraging and clearly not in the best interest of that child.
Thank you, my lord. Much obliged. To answer your lord's first question of, isn't that too much? I believe this is not too much because at the end of it all, it's not excessive and arbitrary. This is got from Article 17 of the International Covenant on Civil and Political Rights under the Syracuse Principles. It says that it shall not be excessive or arbitrary but proportionate. And in this case, it has been proportionate.
I'm going to give you an example. From this competition, imagine we monitored how your colleagues in the gallery are paying attention to you while you're submitting. That's his attention span, right?
Yes, my
So how
lord.
would that benefit this moot court competition?
Thank you, my lord. Your question answers her question. Monitoring the attention of the children.
Counsel,
Monitoring.
the gallery, please be calm. We are here to learn. So what I'm saying is, okay, the attention span of the students
Yes, my lord.
may be a good thing, right? But don't you think that attention span and performance are not correlated? I'll give an example. For most of my high school life, I was a backbencher, okay? I don't think I paid attention in any English class, but I had a D1 in English. So my attention in an English class had no correlation with my getting a D1 in English. So one could argue in this particular set of facts that attention span, in as much as it may be a good thing, it doesn't determine how someone performs better or less. For example, some students have autism, okay, which means that they are never attentive in class, but they're very good at math and they pass math. So do you think that it is right for the school to monitor attention span? Don't you think it would have been better for them to limit it to classroom attendance? At least that one is measurable, because if someone is not in class, they won't learn.
Much obliged, my lord. We submit that they shouldn't use only the roll call or attendance, because now it's a new system that's being introduced, the Smart AI Classroom. But how attention works hand in hand with performance is the level to which a student pays focus in class is to what extent they perform well. Therefore, why this monitoring is important is teachers are able to know the weaknesses of their students and now find possible solutions on how they can help them. This is why now the alternative classroom has been created, not for the people that have disabilities, but for the people that are unable to study with the rest of the children. I hope your question is answered. My lord.
I have a question that I asked the applicant. Proportionality in this instance, don't you think it would have been less intrusive had you asked the parents for consent?
Much obliged, my lord. To answer your question, I believe that consent could have been the less intrusive, but it wouldn't achieve the aim within today's case.
How did you determine that it wouldn't have achieved that? And second, what entitled you to a yes from the parents?
My lord, by default, that parents took their children to school simply meant that they consented. However, why we did not take the longer route is because we wanted to handle this urgently to improve. And this is evidence in paragraph 1 and 4. My lord, to answer your question of predictions, indeed, true, it shows them their future prediction, but it has benefits and harms. For those that it shows their future is going to be bright, they are motivated to keep working hard and to be better. For those which it shows that their future isn't going to be bright, now teachers find a possible solution to make sure that they work towards making their future bright. Therefore, inclusive education is then got. My lord, I proceed to make our prayers. We therefore pray that this court to make a finding that the data collection is lawful, proportionate, necessary, and legitimate. Our final prayers for the respondent is that this honorable court, firstly, declares the respondent's collection of biometric and personal data of students was lawful, legitimate, and constitutionally permissible, and we prove this, which applicants failed to do that. Secondly, dismiss the applicant's petition in its entirety with costs of 70 million because they fail to show us its importance. And thirdly, affirm...
Just on that prayer, just a little, would you help this court understand why, you said that you've been making a very passionate argument that your state, the school is very sympathetic, it really does care so much for human rights and all of this, and yet you're asking the court to penalize the students with disabilities with 70 million. They could not afford 1.5 million to pay for the tablets, but you want the court to penalize them with 70 million. Do you think that's a fair thing to? Does it show that you really care, or you're now mad? You're pissed. You want them to know.
Much obliged, my lord.
Yeah?
That is not what I intended to say. I intended to say that the applicants want a compensation of 70 million without showing us the necessary importance as to why we need to give them that.
You just said the court should penalize them.
No, my lord.
I did not hear you well.
I am sorry for my...
Did I get that right?
Counsel, in further to that, do you think that this court ordinarily should award costs in human rights matters given their public importance, or to improve constitutionalism and to enable people bring public interest cases to court, this court should, in some instances, say, let the costs wait. This was very important for us to address, and maybe another time.
Much obliged, my lord. I believe that is according to the rule of the court to be ruled whether they should consider the human rights first or the cost. I proceed to make a second prayer, which is dismiss the applicant's petition in its entirety with costs. And lastly, affirm that educational institutions...
So just quickly.
Yes, my lord.
You wrap up on that. So I'm having a little bit of trouble with this whole costs thing, yeah?
Yes, my lord.
So dismiss the matter with costs, yeah?
Yes, my lord.
Costs to who?
My lord, we submit that the costs weren't submitted by the respondent.
Yes, I'm saying, so if you say dismiss with costs, means
yes, my lord,
that the applicant should pay you the costs of these proceedings, okay? So it's basically saying they've really wasted our time. We would have been somewhere else doing something else. They've wasted our time. We've paid lawyers. So they need to pay us for the time that we have lost. That's what costs really means.
Much obliged, my lord. That is not the intention of the message. Okay. The message...
So you forgive them? If the court finds, do you forgive them? And you're like, okay, fine, we get it. Let the costs lie where they fall. Let each one of us bear their costs, and we are good. Kumbaya.
My lord, according to the case that has been presented before the court, I believe the judges will make a fair hearing.
Oh, beautiful. What was your last...
Yes,
what was your last...
that is where I'm proceeding to. To affirm that the educational institutions in implementing reasonable and proportionate dictator systems act within the permissible limitation of rights to safeguard students, maintain accountability, and promote well-being. My lord, we so pray.
Thank you very much. Thank you very much for that very passionate presentation. We have a rebuttal. Thank you. Remember that in rebuttal, you're responding to what they have said and you're not introducing any new arguments.
Yes, my lord.
Thank you.
Much obliged, your honors. Whereas our land friends, the respondents, argued that the alternative rooms were not injustice, My lords, justice is not disparity in standards, nor is it being excluded from the school's national rankings as my clients were. Hence, this is discrimination on grounds of disability, my lord, which the respondents failed to acknowledge. The respondents also failed to account for the fact that they did not provide protection for my clients, which is provided in Article 21 of the 1995 Constitution, my lord, as the alternative learning rooms were being termed as the left-behind class, which was never dealt with by the school, yet it is their obligation, my lord. In addition to this, whereas we acknowledge that the school, Nakaseke Bright Future Secondary School, has resource constraints, it was not in order that my clients were asked to contribute 1.5 million. My lord, students that go to government-aided schools are not of those of wealthy backgrounds. The requirement that one has to that one is made to pay for what is nature is absurd and violates Article 21, which is supposed to be protecting persons with disabilities. It is therefore with this that I note that my client suffered psychological torture because the state and through the school failed to protect the people with disabilities, my lord. With therefore, I submit. Much obliged, your honors.
Thank you very much. With that said, I believe that we have come to the end of the litigation process. Congratulations to all of you. I, for one, have had a very entertaining, as I said, the most entertaining outcome is the most probable. I've had a very entertaining time, so thank you, each one of you. So the judges will now retreat to compile their marks and come up with a decision. So thank you very much once more, and this matter is now adjourned.
Okay. Thank you so much for that amazing round. Let us clap for our